We're on the air again. This is Radio Entrepreneurs. My name is Jeffrey Davis, always featuring the success of entrepreneurship and helping to promote continued success of entrepreneurship. And if we're promoting the continued success, that means that Mark Furman from Tarlow, Breed, Hart & Rogers is in the studios, our reporter focusing on entrepreneurship and the law. Welcome back, Mark.
Hello, Jeffrey. Great to be with you.
Thank you very much. You're looking quite good, Mark.
I think it's time for an eye exam, Jeffrey, but okay, thank you.
Beauty's in the eyes of the beholder.
That's right.
Right.
That's right. So I wanted to chat today about a interesting case decided not too long ago. It has brings up a number of issues. One in particular for companies, I think, is the enforceability of arbitration clauses. And the background is actually a legal malpractice case, but the scope of an arbitration clause is prominently featured. And the law has evolved so that arbitration clauses will be enforced, and it's a way, if your company wants to avoid litigation, that is being in a judicial proceeding, jury trials, all of the costs associated with that, you have to really consider arbitration as a alternative venue for disputes to be resolved. You have the potential for it to be faster and less expensive. That's the benefit, and usually there aren't any appeals, so that's helpful as well, unless you're the losing side and you want to have an appeal. So there's pluses and minuses. In this case, a woman, a physician, was hired by a physician group at BI Deaconess back in 2002, and she signed an employment agreement that said any dispute that isn't resolved by the parties shall be finally settled by arbitration, and the parties irrevocably waive any right to redress any such dispute other than by arbitration. So this physician filed a discrimination charge against her employer in 2003, was terminated in 2004, and there was the case law at the time indicated that the clause I just read would be broad enough to cover discrimination claims, which was what her claim was. So the defendant moved to compel arbitration. She brought suit, and the Superior Court judge said, based upon the existing precedent, that the case would be stayed and it would have to go to arbitration. I wanted to talk about the case because, first of all, arbitration clauses are critically important, and if you take it out of this, the rule that the Supreme Judicial Court says is going forward, which was a change, that if you want to force employees in discrimination cases to have to go to arbitration, thereby eliminating their right to a jury trial, you must specifically reference the discrimination law. You can't just do it by any controversy. That was the change in the law. So I always talk about people have an assumption that agreements are just boilerplate, and they're not. They need to have specific things.
They can't be soft-sided.
If you want to achieve your goals.